174, People versus Negron. Counsel, would you like any rebuttal time?
2 minutes, Your Honor.
2
minutes.
You've got it. Go ahead, counsel.
May it please the Court, I would like to begin with the Brady point and then address ineffectiveness of time.
Go ahead. Do the Brady point first.
The prosecutor in this case opposed the defense third-party culpability proffer by misleading the defense, and the judge about whether or not there was any nexus between the third-party Caban and the shooting.
What was the nexus?
The nexus was that not only, as the judge was told, did the shooter go into this 3-unit apartment building, that Caban lived in that apartment building, and that he matched Negron in height, weight, age, race, and skin color, and he actually had facial hair which matched description by 2 witnesses, unlike Caban, who did not. But the fact that the prosecutor withheld and misled everyone about was the nexus. And the nexus was that Caban fled his apartment in a panic with bags of weapons and ammunition, ran through a neighbor's apartment, and then went to the roof of an adjoining building, tried to conceal the weapons cache there, and then tried to flee, just as the police were coming to his building, investigating the very shooting that had occurred several hours before.
What do you think is the motivation involved here? In your mind, that the police knew it was too close for comfort?
I mean, that the police...
What's the motivation in not providing the...
Oh, by the prosecutor?
Yeah.
This is the same prosecutor who handled the Caban case. He stated to the court, this is at page 740 of the appendix, I believe it is irrelevant that there was another male Hispanic living in that building arrested the next day for weapons possession that was not even inside, the weapons weren't even inside that location of 583 Woodward Avenue. The weapons were on the roof of the building adjacent. And all those weapons, none of those weapons matched the shell casings that were recovered at the scene. So he's trying to argue to the judge that the fact that the weapons are recovered in an adjoining building somehow makes there less of a nexus, that the fact that they're not recovered in Caban's apartment, and all along he knows, having handled the Caban case himself, that about the circumstances how Caban fled the building in this panicked way as the police approached investigating the shooting. So I can't put myself in his mind, but I can say that when he knows that the court is dealing with the third-party culpability issue, and he knows that the court is focusing on the question of whether or not there's a clear link, which of course is the wrong standard, which he doesn't object to himself, he doesn't correct the court, but knowing that the court is looking for a link, he argues that there's no link and conceals from the defense and from the court evidence that tends to establish a much greater link, and that's a direct link between the police investigating the crime and the actions of Caban.
What is the right standard?
The right standard is the standard that this court established in the People against Primo, which is looking the general evidentiary standard of generally presuming that relevant evidence is admissible, but then looking at whether or not there are other considerations that should counsel the court not to allow the relevant evidence, such as distracting the jury and that kind of thing.
Even though, I'm sorry.
No, please go.
Even though the court said it was looking for a clear link and used that term, but later the court said, but I actually did apply the primo, you call it, primo standard. So what are we to make of that? Did the court use, because it used clear link, but it applied the primo standard, what should we do?
Well, first of all, I don't think my brief made it clear enough that there were 3 occasions when the court used the term clear link. At page 741 of the appendix, he said, this is the first thing he said to defense counsel as he made his proffer. The case law is clear. You have to show a clear link between this person and the crime in question. You haven't shown that. I am denying your application at this time. I will allow you to renew it if you can show a clear link. So then counsel makes further argument, and how does the court resolve that argument? At page 744 of the appendix, he says, I'm going to deny your application. He has no clear link between Mr. Caban and this crime. At no point does the court engage in a balancing. At no time does it indicate that it's exercising its discretion to weigh the probative value against prejudicial effect. And we're talking about probative value on an issue that involves the fundamental right of a criminal defendant to present his defense. In this case, the defense of someone else committed the crime. So I realize that Primo adopted the general relevancy standard, but it's in the context of the absolute constitutional right that a criminal defendant has to present a defense.
Now, you agree that in Primo, the nexus was closer than in this case?
It was, Your Honor, absolutely.
But in this case, the nexus was, I assume you would also agree, is closer to, is more than what they had in Schultz.
Much more.
Okay. So you're saying that that this is enough to get us to Primo, or so that it would be admissible?
Well, the issue really is whether or not there was enough for a reasonable judge to have exercised his discretion to allow the defense. I mean, this Court has established in several different cases in the context of the admissibility of evidence, in the context of a reverse Batson situation, people against Luciano, in the Sandoval context, people against Williams, Judge Abdus Salam, and Cortez, that's the context of the admissibility of evidence, that the defendant has a right to have the court exercise its discretion under the appropriate standard. So here the problem is that the court didn't exercise its discretion under the appropriate standard. It didn't exercise its discretion at all. It just looked for a clear link, and when it wasn't satisfied that there was a clear link, that was it.
Can I go back to your Brady issue for a minute? In his brief, counsel argues that the people, because of course we're reliving this whole thing, that the people argue that because they disclosed the arrest of Caban and the existence of the weapons cache to the defendant at trial, the motion court properly rejected the Brady claim, and that got affirmed. What's the error there?
The error is that, as the Supreme Court said in Banks v. Dretke, and as it said in a number of other cases, defense counsel is entitled to rely on the completeness and the accuracy of the people's Brady disclosure. Mm-hmm. So the people know that the defense is trying to establish a link or a nexus, and the issue couldn't be clearer. This is the pivotal issue of the trial. It knows what the defense is looking for, and it not only withholds its knowledge, but makes a misleading argument.
They have to, because there was a pending case involving this. If they say we've got this case, I would think that part of the argument might be, how much investigation do we have to do for you, Mr. Defendant? We told you, you now go for it.
Well, I think,
or what?
Judge Piggott, you all the times I've argued in front of you, you're a very practical judge. Here you have a situation where the defense counsel says, this is all the information I have. He says on page 742 of the appendix, I am giving the jury all the information that is out there. He clearly doesn't know about it. So this is not a game. The prosecutor knows he doesn't know about it. All the prosecution has disclosed is that there were weapons found that were where the allegation was that Caban had been in possession of those weapons and he was criminally charged, not the circumstances of how he disposed of the weapons.
Was your impression or the impression of counsel at the time that they were being misled by the
Clearly counsel was misled.
Pardon me?
Clearly counsel was misled by the remarks that the prosecutor made.
Intentionally, or I guess that's what I'm looking for. Are you suggesting that the people did it intentionally, or they just did what they thought was enough, and now they're clearly wrong? I'm always curious about Brady because it's not just exculpatory, but that which might lead to exculpatory evidence and things like that.
Well, if Your Honor is focusing on the initial disclosure,
yeah.
The initial disclosure, merely that Caban was in possession of weapons, wasn't enough to indicate to the defense that if it investigated further, it would find out that the circumstances of how he disposed of those weapons. Why would defense counsel, who has so many things to do to prepare for trial, why would he know that there's favorable evidence there about
So you're saying that when they initially made the disclosure, that was all the information they had?
That's right.
But that more information came to light that they then should have disclosed to you?
No, I think the prosecutor had this information all along. What happened was that
prosecuting both.
Who was prosecuting both. What happened was that several months before the trial in this case, there was a suppression hearing in the Caban case. Whether or not that transcript was transcribed and placed in a court file in time for defense counsel to have discovered it, had he thought to look for it, is not in the record.
What about the court said in its 440 motion that it was relying on Rosario material that was supposed to have been disclosed? I can't find it in the record, but I'm assuming that both parties, you can both address it, because I think the people have conceded that they don't have it in the record either. What was the court talking about?
I have no idea. I mean, we argued that part of the Brady violation was that there was .45 caliber ammunition found in the weapons cache on the roof, which was the same kind of ammunition used in the shooting, that was some evidence. I mean, it's not overwhelming evidence, but that's some evidence that tends to show that Caban might have been involved in the shooting. And the people never disputed our claim that was not disclosed to the defense. That's the claim that we made in our 440 motion.
Right.
And all of a sudden, Judge Lasak in his decision says, oh, by the way, there's some receipt that indicates it was disclosed as part of a Rosario disclosure, and Mr. Bradigan, to his credit, conceded it during our leave application in front of Judge Smith, and I think the people have not retracted that they can't find anything in their file to indicate that there's any such document. And we asked this court's clerk to search the record that was here in Albany, and he couldn't find any such receipt
counsel.
either.
You'll have your rebuttal. Let's hear from your adversary.
Thank you, Your Honor.
William Brannigan for the people. Good afternoon, Your Honors. May it please the Court.
Counsel, what about Brady? What did you know, and why wasn't it shared with them on Caban?
Well, Your Honor, basically what's disclosed on the record is that this other man living in the building whose photo was disclosed, Mr. Caban, was arrested the following day with a stash of weapons. The court has also found that, in addition, there was a disclosure that .45 caliber ammunition was found in that stash. So the people basically gave all the information that was needed to at the time. If there was some additional detail, the defendant was at that point in a position to get it.
Here's the problem I have with these Brady things: is it's all it's all the people. You decide, first of all, if it's Brady, and quite often, if there's going to be an error, my thought, I'm cynical, is that you'd err on the side of saying, well, it's not Brady. Secondly, the decision is that, well, it's not favorable to the defendant, and we overlook the fact that it's not only favorable to the defendant, but may lead to evidence that would be favorable to the defendant, and that part gets ignored, too. And you guys are so close to this thing. I just see two weapons things, a shooting, guns and ammunition, all. I would think that the whole thing would get disclosed, saying this is what we got. Not well, maybe this matches, maybe it doesn't, so we don't have to disclose. Why play it that tightly on Brady, knowing that no one else knows what you know? We can't review it.
Your Honor, no one was playing tightly here. He disclosed that Mr. Caban was arrested, that there were these weapons, that it was on the following day. The concern at the time, just to fill in the record, is that there was a .45 caliber weapon recovered. That .45 caliber weapon was tested. It was found not to be the weapon used. Now defendants arguing that there was a consciousness of guilt claim, that the timing of this, the timing of the weapons dump somehow demonstrated the innocence of the defendant. It just didn't. It's extremely speculative. The police officers show up at his house.
You don't turn it over to them altogether?
Well, Your Honor, again,
in other words, you give them what you're supposed to give them, and then they try and defend their client as best they can. Why? I think it's what I'm getting towards is really what Judge Pickett was saying. You have control of all of it. So, yeah, if you pick and choose, that won't really show them anything. Why don't you just give it to them? Isn't that what Brady's supposed to be about?
Okay, two things, Your Honor. First of all, there's an ethical obligation that the people have to disclose exculpatory information, and that comes up beforehand.
Or things that will lead to further information.
Right. Here we're after the fact, so we're addressing Brady, and Brady is addressing the materiality of this evidence at trial. So from that standpoint, we can look at the record here, and if all the defendant is saying is that this could have provided for some kind of consciousness of guilt defense, it just doesn't rise to the level of Brady.
No,
now,
I get mysterious, because suppose you disclosed that you were going to test this weapon. I think they would be interested in that. And then you would disclose, hey, we tested it, and guess what? It's not the weapon. They'd say, let us test it. And wait a minute, we think it is the weapon. And now you've got a real controversy that wouldn't otherwise occur because you tested it and you made the determination that it wasn't the weapon, when perhaps, I'm not suggesting at all that there was some nefarious things going on here, but perhaps they want to test the weapon.
Your Honor, again, that was known at the time. The fact that there was this .45 caliber weapon recovered, that it was tested, that was all known. And just furthermore, I mean, to the extent that there might have been some carelessness here, this Court, if you look at the record of the 440 proceeding, had the people retest the ballistics evidence here to see if there was any link, any way to link that evidence to the shells recovered from the scene. So all of this was done. This case was carefully managed from the start, and it was really about a green card.
I'm sorry, can I interrupt you? Did you say that was as part of the 440?
During the yes, Your Honor. If you look at, there wasn't a hearing in this case, but there were court appearances during the 440 hearing, and at that time, the court ordered the people to have the ballistics evidence that was recovered from Caban retested to see if there was any link between that ballistics evidence and the shells recovered from the scene.
That would lead me to think that there was a Brady violation. Am I wrong?
No, Your Honor. Again, the Brady goes towards materiality. So, yes, if the court or if the people at that time had turned up something in addition, linking that evidence, linking that ammunition to the shells recovered at the scene, that could have made a difference in his third-party culpability defense at the time, yes, then maybe we could get something. We could start rising towards Brady violation, but nothing was recovered. And the fact is this case is about a green car. This defendant was driving a very distinctive green Monte Carlo on the night of the shooting.
Didn't somebody say it was blue, and somebody said it was a two-door, and somebody said it was a four-door?
Your Honor, as far as the two-door, it was at night, so it's not surprising that someone might have called it green. But as far as the two-door versus four-door, look at the picture of this car. It's a very distinctive car. It's a two-door sedan that's in the style of a four-door sedan. 3 witnesses identified this car immediately after the shooting. That's how the defendant's arrested. They get the car. It comes back to him. They go to the apartment where the shooter was seen going. He comes out. He admits that he's the only one driving the car.
Yeah, you know the problem is, though, and this is what struck me in the case, is the car is better identified than the defendant is in this case. In point of fact, you know, you got 3 witnesses, the 2 Russian names, which I don't remember. One of them couldn't remember. 2 of them couldn't identify from a trial. One said it wasn't the person who did it. The car itself seems to have more people identifying and linking him to the crime than people were able to actually link the defendant directly to the crime. So you're right, it is all about the car, but you see the logical fallacy.
Well, no, Your Honor. It's very strong evidence. This is a very distinctive car. It was identified immediately after the shooting. The officer showed up on the scene, felt the hood of the car. It was still warm. So that's the strong evidence here.
Did he feel any other hood? Did he check any other car?
No.
No, right?
But he wouldn't have reason to. 3 witnesses identified that car. 2 are down the block. 1 was with the victim. So 2 of these witnesses didn't even know each other. And as far as the identification here, while the lineup was suppressed, only one of these witnesses had any good opportunity to identify the defendant, and that was the shooting victim.
The person who was shot? Yeah, the person who was shot.
Yes.
Mr. LaFleur. I'd just like to go back to the Brady issue, just so I'm clear about it. You're saying what was not material at trial, that in Mr. Caban's cache there was 45 millimeter ammunition? What was not material that you thought you didn't have to turn over and that they could find themselves, and how would they find that out?
Well, again, Your Honor, it's reviewing the record, reviewing the Brady issue. What remains, because the court, and that's an affirmed finding of the fact, the court has stated that the fact that there was 45 caliber ammunition was disclosed. So that's part of the record. What remains is
even though we don't see that in the record and everybody agrees it's not in the record, do we still have to accept that?
Yes, Your Honor. It was affirmed by the appellate division. It's beyond this court's power to review.
Okay, I'm sorry. Did you answer Judge Abdul Salam's question about what you thought was not material?
Again, reviewing the record here, the remaining claim is basically a consciousness of guilt claim. That is an extremely equivalent argument, meaning that the fact that he dumps these weapons when he sees the officer show up at his house is consciousness of guilt of the weapons he possessed. Notably, the actual shooting weapon is not in that stash. And if the defendant knew that the police were coming for him because he just shot somebody outside of his house the previous night, he would have known to get rid of those weapons the previous night. He wouldn't have been surprised when they showed up at his door the following afternoon.
Okay, counsel.
Okay, thank you, Your Honors.
You're welcome. Thank you. Counsel Rebuttal.
Yes. First of all, on the consciousness of guilt, it's an interesting contrast that Negron fully cooperates with the police. He gives consent to search his car. He gives consent to search his apartment. They don't find any gun. They don't find any ammunition. They don't find any of the clothing that would describe.
What's the facial hair issue? I know there's one, and I've forgotten what it all amounts to.
The facial hair issue was raised in the context of ineffectiveness that Caban had, as you can see in the appendix, it's the next to last page of the second volume, that Caban, this is at page 1070, appears to have a beard and a mustache. and whereas Negron is clean-shaven, and Negron testified that he was clean-shaven. Miley, one of the companion of the victim, Fevrier, got a good look, or should have had a good look, because he was closer to the driver and the alleged shooter than Fevrier was, and he said that the shooter had a beard and a mustache, and defense counsel failed to interview and to present testimony from 11 witnesses who Negron told him could have testified that he would not wear facial hair, and he did not elicit that from the 2 witnesses he actually put on.
What's the connection, the car? That it's his car? Is that what connects him?
Well, no, what I wanted to say about the car is that, as several members of the court pointed out, that there's no right to a Wade hearing for a car. There's no right to a photo array for a car. Here, the car took on more importance than the identification of the defendant. And the way it happened is that the 2 witnesses who had the best view of the car, Fevrier and Miley, said that the car was a 4-door sedan. And then they left the scene. Eventually, Miley comes back. The 3 Eastern European witnesses leave the scene. They come back 15 minutes later, and this is in the record, that at page 552 to 553 of the appendix, one of those witnesses testified that the police directed their attention to this vehicle. So this is like a show-up, where the police and the other eyewitness, Miley, are already gathered around the car. They've already felt the car. They've already felt that it's warm, which has very little probative value. There's nothing in the record about how long a car stays warm. This is a cast-iron vehicle. It could stay warm the engine could stay warm for a long time. There's no expert testimony about that. And Negron testified that he drove home and parked the vehicle about 2:30.
Okay, Kathy. I'm sorry.
No, I just-
No?
never
Okay.
mind.
Thank you both. Appreciate it.
Thank you.